Swayam Prabha. Digital India. Educated India.
Hello everyone, this is my lecture number 3. I am Dr. Shabnam Mehlawat, an Associate Professor from the University of Delhi. I will be continuing with my lecture on international law. Earlier we had discussed the events of international law. Today I will be discussing the concept of sustainable development, which formed a part and parcel of the international environmental law. It is the events which took place which are equally important, and along with that are the concepts and the principles which have developed in the international law and which have been implemented in the domestic domains of the respective states. This concept, it is a juxtaposition phrase where development and protection of environment are to be carried out without contradiction. That is the state's economic right to utilize its resources and environmental law. Earlier I had discussed the concept of sic utiae tu alienum non ledis, that the state has the right to utilize its resources in accordance with its likes and dislikes and according to the laws which are framed. But it cannot, to the detriment of its neighbors or to the detriment of environment or the environmental rights of others, indulge in activities which are environmentally degrading. So this concept has been framed to draw out a balance between the protection actions of environment as well as the law which has been brought into force for economic purposes. So the state, for the purpose of balancing the two conditions of environment and development, this concept of sustainable development was developed over a period of time since the Stockholm Declaration. This holds that development must meet the present needs without compromising the future generations to meet their own needs. Another concept which developed was that whatever resources which we are using, which are natural, which are environmental and which are present in the natural forms, if we degrade and exploit them to an extent, with the current generation making use of them, there will be nothing left for our future generations to make use of. So this concept develops as a balancing act that we only use that amount of resource which are required, and the remaining should be protected and preserved for our future generations. The modus operandi of the concept is based on intergenerational equity, wherein the present generation uses fairness in the utility of natural resources and preserves them for our future generations. It further holds that the natural resources are our global commons. Now, what are global commons? The common resources may be present in a respective country, but it is a common feature which provides a backing to the very life of on earth and for people who are living, breathing into those natural resources. So this concept is basically we protect our resources for the current and our future generations, so that these global commons are protected and preserved while we make use of them either for our economic activities or for our daily lives. The concept rests on the belief that those activities which are known as development but do not protect the environment are outside the ambit of sustainable development. The equity principle further elucidates the concept of preservation and protection for the current and future generations. The Basel Convention on Transboundary Movement of Hazardous Waste, followed more emphatically by the Earth Summit or the Rio Declaration, highlighted international economic law principles for the effective operation of the rules of international environmental law. These rules speak about the protectionist policies, the laws in the domestic domains of each state as well as at the international level. And then it talks about balancing the economic rights with the environmental rights of the people, that we exploit our resources for our economic purposes, but we need to also protect and preserve them by wherever exploitation takes place, we must regenerate them in the form like if trees are felled down, then in those places new trees must be planted which will grow over a period of time. We must take a monetary assignment for cutting down of those trees and then use that monetary fund to re-establish those forests which have been depleted. The concept has developed, strengthened over a period of time, but the drawbacks are felt when the concept and its essentials are not applied fairly and equitably. If it results in an imbalance where economic rights are projected more and environmental rights take a back seat, then in those cases an imbalance is created and the challenges of environmental protection are witnessed, that protection is not taking place to the extent to which it is required. The events which took place prior to the Stockholm Declaration and which led to the development of the concept of sustainable development. Firstly, in Stockholm Declaration, they declared only the soft law principles, principles which every country should work on for protectionist policies of each state. But there were events which led to the Stockholm Declaration and events which led to the framing of the concept of sustainable development. In 1662, John Elwyn in his essay Silva that sowing and planting of trees had to be regarded as a national duty of every landowner in order to stop the destructive overexploitation of natural resources. In the 1600s, possession of land, possession of natural resources was a property of a person, and if it was done away with or exploited, then barren lands would be rejuvenated by planting more trees. The concept was that if you are destroying, it was also in the religious aspect as well as the ownership of rights, the ownership of land aspect, that these rights were emphasized. But they were not really in the form of rights, they were in the form of ownership of land and properties, where they said if land is destroyed, it would be a detrimental effect on the neighbors as well as the person himself. In the 17th and the 18th century, the sustainable forest management developed. In 1713, Hans Carl von Carlowitz, mining administrator, published work on forestry. It was in the 1960s that the Aldo Leopold's land ethics were responsible for the environmental movement. In 1962, Rachel Carson's environmental movement showcased relationship between economic growth and environmental degradation. In 1966, Kenneth E. Boulding's essay on Spaceship Earth discussed economics and environmental systems. In 1968, Gareth Hardin's article popularly gave the phrase tragedy of the commons. But these were very single instances where these people must have witnessed the degradation of environment, and when the Industrial Revolution struck the cities in Europe, they must have felt the need for protection of environment, although they were voiced by a very few people. It was only in 1972 that the world came together under the Stockholm Declaration or the United Nations Conference on Human Environment and Development that they framed the soft law principles, and which also led to the establishment of the United Nations Environment Program. This program facilitated various events for which environment was sought to be protected, and they were based on the principles which later on formed a part of the concept of sustainable development. It was in 1982 that the World Charter for Nature also came in, wherein the soft law developed more, but they were only guidelines where they stated that the countries should involve these guidelines into the national laws of their domestic domains. It was in 1985 of the Vienna Convention that they brought hard law, and they also based them on the principles of Stockholm Declaration, which was polluter pays principle, as well as the equity concept. It was finally in 1987 that the Brundtland Commission report finally gave a concept and a definition of sustainable development. It was done under the leadership of the Norwegian Prime Minister Gro Harlem Brundtland, and they brought out a report which stated that we must protect and preserve our environment by balancing the needs of the current generation with those of the needs of our future generations. The rights of the unborn child were discussed, that those children who are not born today, their rights are being trampled upon by exploiting our resources, where resources will not be left for them to be seen or to be utilized. It was in 1989 that the Basel Convention came in, and they also based that convention based on the principles of Stockholm Declaration and the concept of sustainable development. Finally, in 1992 or the Earth Summit, they gave a broad framework definition and broad framework principles where they sought for balancing the rights, bringing out blueprint plans and taking action under climate change conditions and the Convention on Biological Diversity. After the Stockholm Declaration, a soft law which developed were continued thereafter in most of the meets. There were conventions, there were legislations and there were meetings which took place internationally as well as in the domestic laws of each country. It was followed by the World Charter for Nature in 1982, which reiterated the principles of Stockholm Declaration. These principles were further accepted by the foundation stones of the Vienna Convention on Depletion of the Ozone Layer in 1985, followed by the protocols under it, which was the Montreal Protocol of 1987, the London Amendment of 1990 and so forth. Thereafter came the Brundtland Commission report in 1987, which not only defined the concept by leading it to the formal international law to decide on the rights and liabilities of countries based on these principles. The Brundtland Commission report in 1987, it was the World Commission on Environment and Development, which released this report in 1987 by the, as I stated previously, by the Norwegian Prime Minister Gro Harlem Brundtland, defining the concept of sustainable development. It specifically elucidates on social equity, economic growth and environmental problems. These two, when they are studied in an interrelationship, only can the concept of sustainable development be brought into force. The drafting work began in 1983 by the WCED, which is the World Commission on Environment and Development, wherein environmental problems like ozone depletion, acid rain and other related problems had started, and they formed the Brundtland Commission, which besides working on the definition also worked for long-term solutions of these problems based on the said concept. It ranges over several issues of environmental and equity principle. The Brundtland report is most often cited for its definition of sustainable development as development that meets the needs of the present generation without compromising on the ability of the future generations to meet their own needs. It highlighted on the world population demographics, and the directives were given under the United Nations action for action work on sustainable development, which led to the Earth Summit in 1992 in Rio de Janeiro. So this is basically a background and the coming into force of the concept of sustainable development, that before 1987 there were events which took place, then there were principles which were formed, but the concept as such was talked in a related way or an incidental way, but not as a direct concept called sustainable development. This concept, when brought into force in 1987, incorporated all the principles, all the action work and guidelines of showing a relationship between equity, economic development and protectionist environmental policies. The Common Future report, it was divided into three parts, which was common concerns, common challenges and common endeavors. The common concerns were that it threatened the economic activities and the developmental activities, they threatened our future. They have to work towards a concept of sustainable development, and the role of the international economy in balancing the rights of the people related to environment, as well as economic activities which were also thought as a part of a developmental activity of a country. So these concerns were that since our future is threatened, how do we bring about the concept of sustainable development for the reason for implementation of the same, and how does international economy play a part in the protection of our environment. The challenges before the world were of population, the vicious circle of poverty, the increase in population leading to them feeding more into the natural resources and thereby creating a pressure on the natural resources which would lead to more exploitation, more degradation and more for the hunger of earning money rather than a protectionist policy. The food security. With these industrial activities, food security is now threatened, that there is more and more people moving away from the agricultural practices and more towards economic practices, which is leading to deterioration of the lands and the lands being siphoned away for economic purposes rather than bringing more food production. The species and the ecosystems, half of them are depleted because of these industrial activities. Certain animals like under CITES, which works towards the protection of endangered species, was felt. So, this challenge also was brought that certain ecosystems are disappearing, certain species have completely disappeared and there is no likelihood of those coming back into existence. The vanishing of the species is one of the better examples is that of the bird dodo, which was found in the small island of Sri Lanka. More and more dodo was being used or served as a food commodity for people and thereby the bird species disappeared. When a species disappears, with that another species perishes out. So, when the bird dodo disappeared, a tree in relation to that on which it was dependent also disappeared. So, similarly, more and more species and more ecosystems are disappearing because of the degrading activities, that they perish where exploitation takes place, they perish where the degradation has taken place, they perish where natural resources can no longer be used in the natural way, like water if contaminated cannot be used for drinking or any other purpose. Air if polluted and contaminated cannot be used for breathing, or it may create health issues in people and the living organisms around and other issues which might be part of the natural ecosystems. So, energy. The choices for environment and development is lot dependent on the word energy. The energy levels which may be like if we utilize our natural energy resources, if we use our wind resource, if we use solar energy, if we use the water energy to produce electricity and other forms of modern living, it would be more of a environmentally friendly choice than using diesel fuels and other fuels for the purpose of running an economic activity. The industry which is producing more with less reference to environment is a common challenge, that the industrialist just wants to take away the profits, but does not really bother about the environment or its protection. Then comes the urban challenge, where people are moving from the villages to the cities for better livelihoods, for enhanced manner of living and for an economic status to be achieved. But what they are leaving behind, what they are coming into is overpopulated areas where the system and the essential services are challenged, the pressure on the land comes in, the air problems because of the perishing of the trees poses a problem for air pollution and breathing and other related issues. So, these challenges of urbanization, when they come into existence, also pose challenges for a balancing act of environment and development. The endeavor is how to manage the commons by making economic growth as well as environmental growth in a channelized or a regulated manner, so that if one activity oversees the other, it does not pose a challenge or it does not become an imbalance whereby economic activity overtakes the environmental rights. Then comes the peace, security, environment and development. Peace, like wars when they are fought, if they are using chemicals warfare, if they are using the weapons to destroy one another, it also is a challenge for environment and development, because the natural economies are ravaged as well as what is in the form of development also gets ravaged by the weapons and the war which takes place. So, we move towards a common action where we propose for institutional and legal change, thereby in bringing about environmental laws, a proper implementation of the same, not by any one agency like the government or the agency or the related agencies of environment, but also a people and a community movement where everybody works together for the protection of environment. Then comes the annexes. What are our common future annexes? There are annexes, Annex 1, Annex 2. Annex 1 is a summary of the proposed legal principles for environmental protection and sustainable development adopted by the WCED experts group on environment. The Annex 2 works for the Commission and its work. The caring for the earth. Now, this document, which was brought about in 1987, it brought about principles for sustainable development, it brought about additional actions for sustainable living, and it brought about a proper and a channelized and a regulated manner of implementation and follow up of the policies which are framed. If they are not followed or checks and balances are not maintained on them, then they may grow in a way which might again cause environmental degradation. So, the principles are: we build a sustainable society, we respect and care for our community of life, we improve the quality of human life by bringing in more, but bringing such products and such mannerisms that the environmental resources are not compromised. We are conserving Earth's vitality and there is a diversity of resources. We are keeping within the Earth's carrying capacity. We are changing personal attitudes and practices, and we are enabling the community to protect its environmental rights, not for themselves alone, but also for environment which in its natural resources or in a natural way should be protected the way it is. For example, in a forest which is there, it holds together not only the trees and the fruit which comes out of it, but it also bears with it certain species, certain animals, and if that is removed, then the natural habitat of the species or the living organisms is also removed. So, we need to bring about those principles, specifically the principles of Stockholm Declaration, whereby as a community effort we can protect our environment. It provides for a framework which needs to be developed. Framework includes bringing about the laws and the policies which the government may frame from time to time as the need arises for protection of environment to take place. It should help in creating a global alliance, which is that each country must be working on its own aspects of environment and economic activities, and they must interchange between the two, whereby a balance is created. For example, has the rules or the law related to movement of hazardous waste. Where a country is producing a hazardous waste, it should not allow that waste to be transported to others and letting their liability off, and the poor country or the underdeveloped country is left with that garbage which they have dumped on them, and they do not have the finances and the technology to reuse or recycle the same. So, this is basically where the interchangeable networks also must work for a proper and effective manner of implementation of international as well as national laws. This work towards creating a global alliance whereby each country according to its status must work towards protection rather than dumping of that waste or dumping of their burden into another country for that country to deal with it. The additional actions for sustainable living are energy, the business, industry and commerce, human settlements, farm and rangelands, forest lands, fresh waters, ocean and coastal areas. These areas should be where these protectionist policies must be put into force. That is, where energy is used, we must utilize those resources of energy, we must utilize those sources of energy where they are environmentally benign and not environmentally degrading. The business, industry and commerce should be utilizing products which, if not, cannot be reused and recycled or disposed of in a responsible manner, should not be created before they develop mechanisms to reuse and recycle the same. The human settlements for sustainable living, their environments must be protected and their natural resources around them should be utilized in a way that they again themselves do not create pollutions. Similar thing goes for the farmlands, similar thing goes for the forest lands which are present and which are not destroyed either for the natural resource as a wood or as a timber, or minerals and other economic activities which may find them useful for running an industry. Fresh waters, water should not be contaminated in a way where drinking water is not freely available, where water which is a source of living of all life forms of earth, if it gets destroyed, it will wipe out the population in a way which is unknown, for it might create diseases, it might create the wiping of the population in certain areas. Oceans and coastal regions should be protected and preserved not only for their tourist values, but also for the purpose that they left in their natural forms, they would be not detrimental to the rights of people who are using them. So, strategies must be brought about for a proper implementation of the same. Then annexes in caring for the earth. There have been 8 annexes which are there, which is net primary production preempted or destroyed by human activities, classification of 160 countries by income which has been created, the average life expectancy at birth by 160 countries, and categories and management objectives of protected areas. Annex 5 talks about classification of countries by consumption of commercial energy per person and the total fertility rate. Annex 6 talks about indicators of sustainability. Annex 7 talks about estimated cost of implementing major aspects of the strategy, and Annex 8 talks about strategies for sustainability. Moving now to the principal form of sustainable development, which, as I have previously stated under the international environmental law, that it all started with the formal start in the Stockholm Declaration, and they moved on from Stockholm to the World Charter for Nature, to the Vienna Convention on Depletion of the Ozone Layer, to the Basel Convention in 1989 of Transboundary Movement of Hazardous Waste, and the 1992 Earth Summit, and follow-up principles of sustainable development thereafter, specifically in relation to climate change and specifically in relation to Convention on Biological Diversity. The principles which developed initially were the equity principle or the intergenerational equity, which talks about the protection of the rights of the current generation for our future generations, where a balance between the two is brought about. The equity principle also is brought about in the current context of intragenerational equity. What is intragenerational equity? Equity which reduces the gap between the current generation of countries, where one is regarded as a highly developed country and the other is regarded as a developing country, and a third category which is regarded as the totally low or the least developed country. The use and conservation of natural resources, these must be protected and preserved. There is environmental protection at the base of all this, all the events and all the principles. The precautionary principle, the polluter pays principle, the obligation to assist and cooperate, eradication of poverty and financial assistance to the developing countries, the financial mechanism and transfer of technology. Now, these principles have developed over a period of time and they form an essential part of the concept of sustainable development, including those rights which we talk, including the definition of sustainable development given out under the Brundtland Commission report, which says we must protect and preserve our resources for our current generation to make use of without compromising the needs of our future generations. I will elaborate on these principles one by one under the concept of sustainable development now. Then there was, after these principles have developed, the other important aspect is the economic economics and the industry which has developed, which is making use of these resources to earn economic profits. So, these profits, when they are earned, initially when these systems were developed, these conferences took place, the GATT was developed in relation to economic activities, and it brought about a provision which specifically talked about that where GATT policies or trade policies or the laws are talked about, environmental policies also should be kept in mind while dealing with transactions related to trade. So, it was the GATT Article 20 which said when it was enacted, it contained provisions which along with trade contained certain exemptions favorable for the protection of environment. It made certain provisions exempt from GATT rules, specifically paras B and G of Article 20. These two paragraphs highlighted the cases where inconsistency exists between the trade policies and environmental protection, be it living beings or conservation of natural resources. Despite inconsistencies, provisions may be framed where it adversely affects the trade rules. If trade requires the exploitation of a resource indiscriminately in a way that it will be completely deteriorated, then that trade rule or policy should not be made for the purpose of implementation. So, there it works for the detrimental aspect of the trade, but it works towards the protection of environment. Not all activities or not all trade related activities are environmentally degrading. It talked about only those actions where it leads to indiscriminate exploitation of our environment. So, GATT Article 20 on general exceptions consists of two cumulative requirements. For a GATT inconsistent environmental measure to be justified under Article 20, a member must perform a two-tier analysis proving firstly that its measure falls under at least one of the exceptions, paragraphs B to G, 2 of the 10 exceptions under Article 20, and then the second that the measure satisfies the requirements of the introductory paragraph, the chapter of Article 20, that is, it is not applied in a manner which would constitute a means of arbitrary or unjustifiable discrimination between countries where the same conditions prevail, and is not a disguised restriction on international trade. So, as I stated previously, trade policies, laws and other assignments should be made in a manner which balances both the rights, both for protection of environment as well as carrying out healthy trade transactions whereby it does not affect the environment adversely. Then comes talking about the equity principle. Equity principle talks about equality, fairness, justice. Now, this equality, how do we bring about? We balance development work where environment also is protected and where development also takes place. Say for example, in India, we have a provision that if we clear a small area of forest for any personal use, we must ask the person who is making use of the same to have certain funds to be deposited with the government. After the activity is over, those funds will be utilized for bringing the forest land or the wood back to its original form as far as it is possible. So, this works as a balancing act related to equality. It should be fair, that it should not be overpriced and it should not be underpriced, and justice should prevail both with respect to environment as well as trade. So, as I stated previously, equity principle talks about bridging the gap between the current generation, that is the rich and the poor countries, and also bridging the gap between the current generation and our future generations for whom the likelihood of looking or seeing certain natural species is absent. It talks about the principle of conservation. The principle states that each generation should be required to conserve the diversity of the natural and cultural resources base so that it does not unduly restrict the options available to future generations in solving their problems and satisfying their own values, and it should also be entitled to diversify comparable to that enjoyed to the previous generation. So, the principle of conservation of equality, it talks about each generation should be required to maintain the quality of the planet so that it is passed on in no worse condition than in which it is received, and it should also be entitled to planetary quality comparable to that enjoyed by the previous generation. So, this is conservation of quality. And then the principle of conservation of access. It states that each generation should provide its members with equitable right to access to the legacy of the past generation and should conserve this access for our future generations. The elements of this principle meet the 4 criteria. They should neither authorize unreasonable exploitation by the present generation nor impose unreasonable burdens on present generation to meet in terms of future needs. They do not require predicting the values of our future generations and provide flexibility to future generations to achieve their own goals. They should be reasonably clear in application to see a foreseeable situation, and they should be generally shared by different cultural traditions and acceptable to different economic and political systems. So, this principle of equity basically talks about not compromising on any resources to be exploited, the present generation to make use of, bridging the gap between the current generation of rich and poor by providing those who do not have enough to those resources which should at least be bearable for them to survive, and the rich countries should be the ones, since the pollution has been created by them, for them to transfer finances and technology to receive the same. It is this principle which was based for the Vienna Convention as well as Convention on Climate Change. Moving on to the next principle is use and conservation of our natural resources. The natural resources are those which are freely available as our natural environments, which are considered to be a natural resource available as in land, air, water, wind, sunlight, vegetation, mountains, plains, atmosphere, the seas and oceans, and it is not an exhaustive list which I am presenting here, but an enumerative list which constitutes a part of our natural resources. These resources or natural resources are a natural heritage of all living beings, which is the duty of the current generation to protect and preserve them and to make use only if it does not destroy the nature as advocated under the previous equity principle. These natural resources are measured by the modern world for their intrinsic values and when converted into commerce for their economic value. Some natural resources are renewable, the others may not be renewable. When these resources are exploited for their natural uses, they have a detrimental effect, specifically if they are non-renewable resources like mining of various kinds, which may be iron, which may be sand, or whatever for the purpose for which mining takes place. Then there may be petroleum, the petrol which we use in running our cars and at times even in our industry. It is a non-renewable resource which once used cannot be brought back. Then comes timber. Timber may be renewable, but it takes years and years to develop the same amount of timber which we exploit in one day for the purpose of renewing the same as a renewable resource, which is artificial creation of industries and using natural resources as their base. On the other hand, producing materials which is hazardous, for example, plastic waste and no facilities for disposing it after it has been used, this causes serious concerns for natural resources for creation of an unhealthy planet. The availability of these natural resources often leads to disputes where depletion and overconsumption of resources causes environmental damage. Sustainable development is the answer for these agendas and goals, and it is established on international platforms to deal with environmental degradation problems and with environmental protectionist policies which are framed in the current date in the form of SDGs or the Sustainable Development Goals, which require protectionist policies to be framed and implemented. An example of the same would be to recycle and reuse the same rather than exploit new resources for creation of for the same industry. to earn economic profits. Where profits have already been achieved by industrial activity, it needs to be the end product, which might be in the form of a waste, and in case it is a hazardous waste, means must be found to recycle and reuse the same for another product to be developed, rather than exploiting the current resources for exploitation purposes and continuing the trade in the same manner. Then comes use and conservation of natural resources. Resources have been divided on the basis of their origin, which is biotic and abiotic resources. Biotic resources originate from the biosphere and include fossil fuels, whereas abiotic resources originate from inorganic or non-living matter. Resources too have various stages of development as potential, actual, reserves and stocks. Potential is that the resource still exists, but it has a potential to be exploited. Actual is what is currently existing and is being made use of. Reserves are where we know that the resources are existing, but we do not use them, thinking that in future years we might be able to use them when there is a dearth or a paucity of those resources not being available. And stocks are where already use has been made and we are stocking that resource for the purpose of making use of it in a regulated and in a systematic manner. Resources are also considered, as I stated previously, from renewability and the non-renewability basis. They are considered also from ownership basis, which could be individual, which could be a community resource, which could be a national resource, or even a state-based resource, or international resources, which are common resources of all countries, such as international waters, the right to way, the right to passage in a country, which might be in the form of waters, the backwaters, etc., are ways where natural resources work in a systematic and in a very global way, where alliances are being created for certain natural resource systems to remain as they were, as we had in our traditional societies. Use and conservation of resources. There are 4 activities which take place. One is extraction, where resource extraction involves any activity that withdraws the resource from nature. It can range in scale from the traditional use of pre-industrial societies to global industry. Extractive industries are, along with agriculture, the basis of the primary sector of the economy. Extraction produces raw materials, which is then processed to add value. Examples of extractive industries are hunting, trapping, mining, oil and gas, drilling and forestry. Natural resources can add substantial amounts to a country's wealth. Then is depletion. A complete extinguishment of resources is felt slowly as it relates to depletion, that we slowly and steadily make use of them and they completely extinguish in a very slow and a phased manner. Then comes the protection. The World Charter for Nature recognized the need for protection against depletion for the first time, and then there is the management of resources, where we are making use of them, we are protecting them, and we are also preserving them for our future generations. So, natural resource management is a discipline in the management of natural resources such as land, water, soil, plants and animals, with a particular focus on how management affects quality of life for present and future generations. Sustainable development is followed according to the judicial use of resources to supply both for the current and the future generation. Then comes environmental protection. The Stockholm Declaration for the first time elucidated on the need to protect nature by way of principles. The third generation human rights or solidarity rights reflected on protection of resources for community purposes. Environmental protection requires collective working of all people, community and other groups. The objective is protection of environment from potential dangers of degradation and exploitation causing permanent damage. Where damage takes place, the need is there to repair that damage. The pressure on natural resources is felt from overconsumption, degradation, population growth, feeding more and more into our natural resources, the lack of knowledge and technology to utilize these resources judicially and thereby protecting the environmental protecting these resources from environmental degradation. Human rights, solidarity rights and principles of the Stockholm Declaration realize the impact of human activities and the detrimental effects of the same on environment, thereby calling for protectionist measures related to the natural resources, or in other words, seeking environmental protection. Creating awareness is a key for organized work for protectionist policies to be brought into place. That is, if we create awareness or to people who might be otherwise oblivious to the fact that environmental resources are being degraded, and protection may be provided by this awareness which might be created. The polluter pays principle. Now, this is an ancient principle which was based on property rights and which was based on the rights of the neighbor. Earlier societies had lands and property as their personal right. So, where exploitation takes place in one land and it affects the neighbor would seek remuneration from the person who has created that pollution. So, it is an ancient principle which talks about the polluter should be made to pay. This has also been famously dealt with in the case of Raylands versus Fletcher under the concept of strict liability, where it states that where detrimental harm comes to a person's land because of the activity of another, which may be natural, but when it escapes causing danger to others, then the person who brought that activity should be responsible and should be made to pay for the damage which he has caused. So, this principle, it makes the polluter liable for harm or damage caused by him. The onus lies on the polluter to show how his activity should not be made responsible for the damages. It relates to economics of activities to environmental matters, and it is strongly used by European nations and supported by the OECD, which is the Organization for Economic Cooperation and Development. It was frequently mentioned by a French historian, Jean Baptiste, in the 19th century for compensation in environmental matters. The current laws after the Stockholm Declaration and after the various industrial disasters and other disasters which have struck various countries, this principle has become the norm in every country, where they have framed laws whereby compensation comes in the form that if a polluter, if a person is liable for, has created pollution, he will be liable for the harm which he has caused, not only to the people but also for the environment, and will be also responsible for bringing the environment back to its original form as far as it is possible. So, the current laws are framed on the said principle, where compensation is talked about for harm or detrimental activities caused by individuals or industrialists. The polluter pays principle and the Indian law. Two of the famous cases which were brought into force by our courts and highlighted while bringing decisions with respect to harm caused to the environment, it was one of the cases was the Indian Council for Enviro Legal Action versus Union of India. The court laid down the question of liability of the respondents to defray the costs of remedial measures, which can be looked into from another angle, which has now come to be acceptably universal sound principle of polluter pays principle. The polluter pays principle demands that the financial costs of preventing the remedying damage caused by pollution should lie with the undertakings which cause the pollution or produce the goods which cause the pollution. Under the principle, it is not the role of the government to meet the costs involved in either prevention of such damage or in carrying out remedial action, because the effect of this would be to shift the financial burden of the pollution incident to the taxpayer. So, it is the person who has created the pollution will be made to pay and not the government or any other related agencies. This principle was also promoted by OECD during the 1970s, when there was a great public interest in environmental issues. The next case which comes in India is the case of Vellore Citizens Welfare Forum versus Union of India, where the leather industry in the state of Tamil Nadu had started polluting the river, which was a seasonal one because of that industry being a major foreign exchange earner. And the court ruled that once the activity carried on is hazardous or inherently dangerous, the person carrying on such activity is liable to make good the loss which he has caused to any person, irrespective of the fact whether he took reasonable care while carrying on his activity or not. Consequently, the polluting industries are absolutely liable to compensate for the harm caused. In India, we do not accept the exceptions of the strict liability or the no fault liability principle. The Indian courts have brought in the principle of absolute liability in contrast to the same, stating that if pollution is caused, then the person has to pay despite any exceptions being existing or being made implementable. The court lays absolute liability for the harm which is caused to the environment, and it extends not only for compensating the victims, but also the cost of restoring the environmental degradation. Then comes the precautionary principle. Now, this principle has been discussed in detail, but in the current issue also, going back to the previous lectures, this principle was earlier talked about as the principle of certainty or the assimilative capacity principle, which talked about certainty of science. Whatever science does is certain, whatever science does is good, it will not bring about any harm, and it will work for the betterment of human life. This was the concept based on assimilative capacity principle. Then slowly in 1982, when they realized that all scientific activity or all industrial activity may not be good, may not be based on certainty of science, the results may be felt later on, it changed to the precautionary principle. This principle says before you start a new activity, you must run trials, you must see that the activity is not causing any harm, it is not environmentally degrading or not exploiting any person or natural resource. Only then licenses should be given to the industrialists to run this activity. So, it relates to risk management. It means thinking of future possible harms and of a way to minimize or altogether avoid such harms. The Supreme Court of India has elucidated the precautionary principle in the context of the municipal law, which means environmental measures by the state government and the statutory authorities must anticipate, prevent and attack the causes of environmental degradation. Where there are threats of serious and irreversible harm, lack of scientific certainty should not be used as a reason for postponing measures to prevent environmental degradation. And when a new activity is proposed to be started, where license needs to be given for running that activity, the onus of proof shall lie on the developer or the industrialist to show how his activity is environmentally benign. The precautionary principle, as I previously I have already given you the background of the assimilative capacity principle. This is formulation of this principle in contemporary public policy, and it can be traced to the early 1950s, which called for a safe minimum standard of conservation. It paved in the 1970s, where limitations of public policies was based on the notion of assimilative capacity. That is, the humans in the environment can tolerate a certain amount of contamination or disturbance, and this amount can be calculated and controlled. It changed to the precautionary principle in 1982. In the mid-70s, 1970s also, the West Germany's legislature enacted a national forest policy which provided for a precautionary approach to environmental protection, coined as the Wasserprinzip. The pronunciation would be in accordance to the German language. It is more vocal after 1982, which was specifically discussed in the Rio Declaration or Agenda 21 of 1992, which states that in order to protect the environment, precautionary approach should be widely applied by states according to their capabilities. Where there are threats of serious or irreversible damage, lack of scientific certainty should not be used as a reason for postponing measures. It was in 1998 the Wingspread statement also talked about the precautionary principle in a similar manner. Then is the obligation to assist and cooperate. This principle of cooperation and assisting those who are in need of help for a better policy to be framed, for a better industry to develop, and for ways in which environment should be protected is a reason where several conventions have been brought into force. This duty to cooperate was recognized in Principle 24 of the Stockholm Declaration and repeated in Principles 7 and 27 of the Rio Declaration, where the duty to cooperate has been a near constant inclusion within multilateral environmental treaties and is recognized as a fundamental principle. The obligation has been obligated under international environmental laws, where due diligence should be used to cause no harm to the environment. Environmental impact assessment is a key to starting any new activity, and the state is a trustee of a resources which is obligated to not provide licenses to those activities causing environmental harm. Community interest should be taken over any personal interest of any personal persons or industry. Eradication of poverty. Poverty has been a reason for differentiation between various countries for progress, for developmental purposes, for urbanization and industrialization. Equity principle works for reducing the economic gaps between nations, specifically as we have previously discussed, the intergenerational and intragenerational equity. The this principle has been specifically brought into force in the Vienna Convention of 1985 of the depletion of ozone layer, where economic status was the reason for disputing disparities. The Earth Summit brought poverty as one of the reasons for removing imbalance between countries. The World Summit on Sustainable Development 2002 worked for the third world countries and helping them come out of poverty, and it is provided as basic needs to all human beings as a part of basic human rights. Then it brought about the Millennium Development Goals and the Sustainable Development Goals. Eradication of poverty and the vicious circle of poverty. When a country is brought out of that vicious circle, it is then that sustainable development can only take place. Because when it feeds into the natural resources, the people are not able to come out of their poverty reasons, and they make poor and uninformed decisions for development purposes, where it might again degrade the environment. Financial assistance to developed and developing countries. This has been given, as I stated previously, based on equity, based on financial assistance, based on technology, helping the country not only to industrialize in a responsible manner, but also to develop and bring themselves out of their vicious circle. The official development assistance is defined as the government aid that promotes and specifically targets the economic development and welfare of the developing countries. The DAC adopted the ODA as the gold standard of foreign aid in 1969, and it remains the main source of financing for development aid. Transfer of technology. This is talked about the formal transfer from one entity to another for working solutions for protectionist environmental action. Intellectual property rights are formed with respect to technology transfer. It is transfer in practice, and it takes place at different levels, that is business, organizational, educational institutions and otherwise. There are various steps to transfer like knowledge, disclosure, assessment, evaluation, IPR rights, research, product development, to name a few. It makes accessibility of technology available to a large number of people and large entities. Methods of transfer. These are spin-outs, informal promotion, educational and research institutions with IPR policies, technology entities like organizations, offices, support centers, marketplaces, and the government. Then comes the principle of common but differentiated responsibility. After the world met with all sorts of principles for bringing about conventions for better action work on environment, they, under the Convention on Climate Change, brought about the principle of common but differentiated responsibility, where the responsibility of each country lies on the status of each country, and the economic disparity can only be reduced by bringing a balancing act of the concerned nations. The objectives is equality, justice, cooperation, and as I stated, it has been previously used in several conventions. So, I would like now to conclude my concept of sustainable development with all these principles and with all these ingredients. It is not an exhaustive list, but an enumerative list which can include other points for the purpose of sustainable development. This is the conjoining principle for all protectionist measures. It is a framework to make laws and policies for various issues and brings about a balance between economics, environment and social well-being. It helps in achieving solidarity rights for environmental violations, and it also helps the SDGs to attain their goals, where we work with an environmental integrity for the current and the future generations. Thank you.